My name is Alexander McMurdo, and this is my Week 5 presentation for global law. Within this video, I will be discussing certain aspects of private international law, and the two outlined questions for this presentation are, number one, the term private international law is sometimes synonymously used with conflict of laws. What is private international law, and what are the three main issues that are commonly dealt with regarding private international law? The second question to be discussed by myself is, what are the various aspects of international law? Now, the Australian Law Dictionary, written by Oxford, defines private international law as the subject area and bodies principles in local legal systems governing private relationships where different bodies of law intersect globally and locally. What this means is private international law's principles are surrounded by legal problems or issues that essentially involve more than one legal system, or in other words, more than one nation. Although this may sound simple, it covers multiple types of legal aspects. These can vary from things of contract law, tort law, family law, and succession law, just to name a few. The main reason why the terms of private international law and conflict of laws are used interchangeably or synonymously is due to the fact that laws from different countries can conflict one another from time to time. It is the role of a private international lawyer to try to work out an avenue to solve these legal disputes that often conflict one another. What this means is private international law provides the rules and legal avenues to pursue any international legal problem at hand. Now, to answer the first question, the three main issues that are most commonly dealt with in private international law are, number one, jurisdiction, number two, choice of law, and number three, the recognition and enforcement of foreign court judgments. Regarding jurisdiction, the first point, this involves the issue of which court should hear the dispute. For example, if a German man was to marry and have children with a woman in South Africa, who then lived in Canada and eventually moved and divorced in Australia, which country would be in charge of these legal proceedings? Particularly if this man, when they did get divorced, took his children back to Germany. What court would be in charge of the custody issues that could and would be raised? Another example would be if a couple were badly injured on a cruise ship in international waters due to negligence from the cruise crew. Which nation would be in charge of the legal proceedings? Jurisdiction can, and often does, become shared between multiple nations. Within Australia, things to consider are where the parties live, the costs that would be involved in travelling, and if there are alternative methods, such as virtual sittings, for example. Now, regarding the second issue of choice of law, this surrounds what type of law would apply. Now, this can vary. If I was to bring up the previous example of the family matter I raised, the choice of law would be whether it's South African, Canadian, German, or Australian. Which law would apply for a family matter in this case? The Family Law Act of Australia recognises marriages from all of these nations, so it is likely this example would be heard in Australia, and Germany would adopt the decision made by a family court judge in Australia. If we were to talk about contract law, for example, it could be based between two companies. Let's say a German car company has a contract with a cargo ship company that is registered in New Zealand. This could be based around whether there are express or implied terms in the contract, and whether those terms were inferred or expressly laid to relate to a certain nation or a certain nation's legislation. If we were to talk about tort law, this would usually surround where the wrong or where the injury had happened. So if we come back to that cruise ship example I gave previously, the choice of law would be which country the cruise ship was registered to. That is how Australia would interpret it. Even though the injury happened in international waters, it would be where the cruise ship was registered to. That would be the choice of law that would be implied. Lastly, the third point that I had at hand, the recognition and enforcement of foreign court judgments. This relates to, say you have a decision from a French court and a French company is entitled to payment due to breaching aspects of the contract. This could relate about how the French company goes about their decision. This could also relate to how the French company will go about enforcing a decision if someone's assets were in Australia, for example, or even a different nation. How would Australia then adopt the judgment that was laid down by the French court? The Foreign Judgments Acts in Australia lists that there are multiple countries that Australia typically recognise and enforce. Now, not every country in the world is on this act. If, for example, a country was not on this act, a private international lawyer would have to apply to have this foreign court judgment recognised in Australia. Now, if I was to summarise the question that was just at hand, the three main issues surrounding question number one are jurisdiction, choice of law, and the recognition and enforcement of foreign court judgments. Now, to come back to the second question, that has briefly been dealt with within the first, the various sources of private international law entail these sorts of things. Private international law derives, or is sourced from, the domestic laws that come from states or nations throughout the world. This means that all nations have their own individual legislation surrounding private international law, and this obviously means that they can differ and do differ from nation to nation. Each country has their own legislation, particularly in regards to what sort of law is being argued, whether it's contract, tort, succession, family law, just to name a few of the common ones. The source of private international law, and the answers that can be found within Australia. These relate to how international laws are influenced, and they tend to be influenced by our own domestic laws in Australia, for example, French domestic laws in France, for example, or German domestic laws in Germany, for example. Now, most Western nations have pushed for a sense of mutual legislation in international law by creating treaties, such as the World Trade Organization, for example. This is to ensure a sense of obligation between nation to nation, and to create a lens that not just the legal minds of Australia can comprehend, but more importantly, that some sense of the global population can come to recognise too. If I was to answer and to conclude the sources of law, we base our international legal rights and our values on the domestic common values that we have in our own countries. How we use those to mediate with other foreign nations or states to achieve results that not only our citizens in Australia can have, but also how people who reside or visit in Australia can also benefit from. This has created a mutual sense of obligation. That means that there is some sense of clarity and harmony from nation to nation throughout the world. I'd like to thank you for taking the time to listen to the perspectives I have studied from analysing private international law, and I look forward to learning more about global law in general throughout the rest of my trimester. Thank you very much.